is Childrey, and I'm an associate at CowanGates. I focus primarily on domestic law, which includes custody, divorce, and child support, as well as criminal law. I initially didn't see myself as a family law attorney, but what drew me to this practice was the ability to help people and guide them through a part of their life which is very tumultuous and has a lot of emotional ranges. So I thought it was a nice thing to be able to do with a law practice. Family law encompasses everything, and I know that's a broad way of putting it, but emotional issues, mental health, counselors, therapists, they're always in the mix. You've got financial issues of accounts that might be joined, or retirement issues, pensions. So not just financial, not just emotional, but there's always the practical side, especially if children are involved, who's going to do what. Traditional roles that one party might have filled in the past are now going to be dually allocated. Essentially, family law will touch almost every part of a person's life. If someone is thinking about ending a relationship and certainly contemplating a divorce, certainly initially speaking with an attorney is a good idea to get a range of options as to what's available and appropriate for each person's specific situation. Virginia is a no-fault state, which means in addition to fault-based grounds, adultery, cruelty, desertion, there is also an option of a no-fault, which is irreconcilable differences and the parties living separate and apart for a period. In Virginia, if there are no minor children involved and the parties have signed a contract between the two of them, which is known as a property settlement agreement, they can get divorced within 6 months. There's a 6-month mandatory waiting period. If there are minor children involved and the parties have a property settlement agreement, the only difference is they must be separated for a minimum of a year, so 12 months. If the parties were married in Virginia, they might consider filing where they were married or where they presently reside. Traditionally, both parties will consent to file for divorce in the county that they last cohabitated as a couple, and traditionally that's where we see couples filing. When custody and visitation of a child is at issue in a specific case, the judge is directed to look at 10 factors that are set forth in the Code of Virginia. It's Code Section 20-124.3, and those factors apply specifically to children living in Virginia. Once a child has been a resident of Virginia for a minimum of 6 months, the state or the Commonwealth takes jurisdiction over that child and will look to those 10 specific factors. In addition to handling domestic cases, I also handle criminal cases. And what one often finds is that in the high emotional context of a divorce or the end of a relationship, behaviors can often cross the line and become criminal in nature. I handle cases ranging from criminal traffic infractions to protective orders to cases of domestic abuse and assault, as well as a felony. This gives me a unique perspective when taking on a domestic client, is to guide them through the process to avoid any pitfalls that might happen. My name is Childrey. I'm an associate at CowanGates, and I'm here to help.